Okay, welcome again. And this is the second lecture, and it relates to criminal justice administration in the trial stage. Okay, in the previous lecture, we discussed about the pre-trial stage of the criminal justice administration, and in this stage, in this lecture, we will discuss about how a criminal trial is conducted with regards to the offences committed by the accused. Now, in this case, we will recapitulate what we studied in the previous lecture with regards to the categorization of offences. Now, firstly, as already stated, offences can be cognizable, offences can be non-cognizable, offences can be summons triable, and offences can be warrant triable. Now, depending upon whether the offence is warrant triable or summons triable, the trial of the offence is segregated in the similar manner. Now, the categorization of offences according to the IPC and the special acts and the jurisdiction of which court can try the offence is found in the first schedule of the CRPC. Now, for your convenience, I have prepared an abstract of the chart in the CRPC, and in this you can see that the chart has different columns, and I have just taken out some of the important or the common generally known offences. Now, if you look at this, you will see that section 302, which deals with murder. Now, section 302, which deals with murder, and it is punishable by death or imprisonment for life and with fine, is a cognizable offence. It is non-bailable, and it is tried by the Court of Sessions. Now, similarly, you have 304, which is a culpable homicide not amounting to murder if act by which death is caused is done with the intention of causing death, etc., etc. Now, for this, the punishment is imprisonment for life or imprisonment for 10 years and with fine. The offence is cognizable. The court which tries the case is the Court of Sessions, and again, the offence is non-bailable. Now, there is another offence under section 323, which is again very common. It is basically voluntarily causing hurt. Now, what is the imprisonment? For 1 year or fine or 1,000 rupees. Now, it is a non-cognizable offence. It is tried by any magistrate. It is bailable. Similarly, theft, which is punishable with 3 years and fine or with both, is a cognizable offence. It is triable by any magistrate, and it is a non-bailable offence. Now, there is second part to the first schedule, which deals with classification of offences in other laws. Now, the first part only deals with classification of offences in the IPC, and in the second part, it is classification of offences against other laws. Now, here the classification is not done according to individual offences, but the classification is done according to the imprisonment or the punishment which is given for the offence. Now, for example, if in any other law, which is not in IPC, but there is an offence, then if the offence is punishable by death or imprisonment for life or imprisonment with more than 7 years, then that offence becomes a cognizable offence. It is a non-bailable offence, and it will be tried by the Court of Sessions. Now, if the imprisonment for such offences is 3 years to 7 years, then again it is a cognizable offence, it is a non-bailable offence, and it is again tried by the Court of Sessions. Now, if the imprisonment is for less than 3 years, it is a non-cognizable offence, it is a bailable offence, and it will be tried by the Court of Sessions. Now, what must be remembered is some of the special acts, it defines as to the punishment, and it defines also with regards to the court which will try the offence. And it also defines whether the offence is bailable or cognizable or non-cognizable or non-bailable. So here the part 2 of the CRPC's first schedule is applicable to those special laws where specific court for trial, specific cognizability or non-cognizability or bailable or non-bailable of the offences description is not given. Now, as we stated earlier in the lecture, offences can also be summons triable and offences can also be warrant triable. Now, we will first consider offences which are triable, summons triable offences, and now summons triable offences can be again segregated to 2 parts. Now, what are these parts? The first part is when the complaint or the case is initiated on the basis of a police report. As we already stated in the earlier lecture, a police report can either be a charge sheet submitted under section 173 or it can be a police report after investigation under section 155. Now, again, we already stated what a summons triable offence is. A summons triable offence is an offence where punishment for the offence is less than 2 years imprisonment. And similarly, a warrant triable offence is an offence which is punishable with imprisonment for more than 2 years. Now, trial of warrant cases by magistrate you will find under chapter 19 of the Criminal Procedure Code. So, first we will consider trial of warrants cases where the warrant case is instituted on a police report. So, we've already told you what a police report is. Now, say a warrant case when it is instituted on a police report and the accused is produced before a magistrate, then the magistrate must first satisfy himself that the provisions of section 207 has been complied with. Now, what is provisions under section 207? It is supply of copies of all documents and evidences on which the prosecution intends to rely to prove the case to the accused. That means the accused must receive all copies. Now, once the magistrate is satisfied that all copies have been supplied, then he will look into the police report, he will consider all the materials that is in the CD, and then if he is satisfied that he has sufficient grounds to proceed with the offence, then what he will do is he will examine the accused and he will tell the accused what is the offence that has been alleged against him. So this is basically consideration of charge. Now, at the time of consideration of charge, the magistrate will explain to the accused what offences have been committed by him and what will be the charges that will be brought under him. Like, for example, 300 true IPC, 379 IPC, these has to be explained to the accused. Now, when this charge is explained to the accused may either plead guilty or he may not plead guilty, and he may claim to be innocent, or he may refuse to plead. So now if the accused pleads guilty, then the magistrate will record his plea of guilt and proceed to convict him if he does not proceed to convict him. Now, if the accused doesn't plead guilty, or refuses to plead, then what the magistrate will do is the magistrate will draw up formal charge against the accused, and while drawing up formal charge against the accused, the magistrate will read over and explain the contents of the charge to the accused and record in writing the pleading of the accused, that he has pleaded not guilty by saying "Ami nirdosh" or "I am not guilty, I have not done the offence." So those details must be there in your charge. Now, after the charge of the accused is completed, after the charge is framed against the accused, then what what the magistrate does is the magistrate calls upon the prosecution to begin its case. Now, the prosecution will begin its case by first introducing the case and then will examine their witnesses. Now, these witnesses will be examined by the prosecution. The method in which the prosecution will examine is, first, the witness will be examined in chief, and then the defense may cross-examine the witness, and then the prosecution, if necessary, may re-examine the witness. So this is generally the procedure in which a witness is examined. First is examination in chief, then cross-examination, then re-examination. Now, once the prosecution has completed examining all the witnesses, the prosecution may also ask the magistrate to call upon some other witnesses. And if the magistrate is so satisfied that the prosecution needs to examine further witnesses, the magistrate may issue summons upon the witnesses. And when summons are issued upon the witnesses, then the magistrate may direct that the expenses incurred by the witnesses for attending court to give evidence may be paid by the prosecution. Now, when the prosecution finishes the examination of the witnesses, then the accused will be called upon to enter into his defense. Now, when the accused enters into his defense, he may also be allowed to examine his own witnesses. The accused may also request the magistrate that witnesses may be produced, may be called upon to give evidence, documents may be produced, or some other evidence may also be produced before the magistrate. Now, the magistrate, if he thinks fit, may direct the production of the witnesses, may call the witnesses into attendance, but the magistrate may also refuse if he thinks that the accused, during the time of cross-examination, has primarily entered into his defense completely, and the accused is merely calling upon the witnesses as a ploy to extend the procedure of the case. Now, once the accused completes his defense witnesses, then the magistrate, if he considers that the accused there are sufficient materials to hold the accused guilty, then he may first write a judgment or an order of conviction if the magistrate considers that he need not proceed under section 235 or 360 of the CRPC. Now, we will discuss what is 235 and 360 CRPC later on. But if the magistrate finds that the accused is not guilty, then he will order the accused to be acquitted and discharged. Now, we just completed the trial of warrant cases instituted on police report. Now, the CRPC provides you with a different procedure where warrant cases are instituted otherwise than on police report. So here, we're basically talking about a complaint that is filed before the magistrate, and then that complaint shows that a cognizable offense has been made out, and then you proceed into trial. The accused is summoned, and then you proceed into trial. Now, in a trial of warrant case before a magistrate, otherwise than on police report, when the accused appears before the magistrate or is produced before the magistrate, again the magistrate will have to supply copies with regards to all the evidences and essays and whatever documents that the complainant wishes to rely upon. And then before the accused, then the magistrate will proceed to examine the complainant and his witnesses on oath. Now, this examination by the magistrate of the complainant and his witnesses on oath is called evidence before charge. Now, in the evidence before charge, the complainant is examined, the witnesses are examined, all documents are laid down into evidence, they are entered into evidence and marked exhibit, and thereafter, the accused may either cross-examine or not cross-examine those witnesses. Now, once all these witnesses have been examined by the court before charge, which is under section 244 of the CRPC, after they have been examined and the magistrate is of the opinion that there is sufficient grounds to proceed against the accused, then he may proceed to frame charge against the accused. Now, the procedure for framing the charge is as in the warrant tribal cases on police report. So similarly, here again, the magistrate will read out the charge, will explain it to the accused, and the accused may again either decide to plead guilty, plead not guilty, or refuse to plead. So similarly, as in the previous case, when the accused pleads guilty, the magistrate will proceed to convict the accused or sentence the accused, and then if the accused pleads not guilty or proceeds to refuses to plead before the magistrate, then charge will be framed against the accused. Now, supposing after the evidence before charge, the magistrate is of the opinion that there is no materials to proceed against the accused, then the magistrate may discharge the accused at this stage. This is under section 245 of the CRPC. Now, once the magistrate proceeds to charge the accused and charge is framed, then begins the examination of the remaining witnesses of the prosecution, in this case, who is the complainant. Now, this is called the evidence after charge. Now, in the evidence after charge, if the accused has not cross-examined the witnesses before the evidence before charge, then he will be given the opportunity to examine these witnesses after charge or cross-examine these witnesses after charge. Then if new witnesses are examined by the complainant, then after the examination is completed, the accused will again be allowed to cross-examine these witnesses after their examination. Once the prosecution completes the examination of the witnesses after charge, the accused will again be, like in the earlier procedure, the accused will be directed to enter into his defense. He may be entitled to produce his witnesses, and then on consideration of all the evidences, the magistrate will either proceed to convict sentence the accused if he finds him guilty, or acquit the accused if he does not find him guilty. Now, so the only difference between the two procedures is, here there is evidence before charge, evidence after charge, but in the procedure where there is police report, there is only a single evidence after the procedure of evidence after the charge. So here, the procedure is the same, just the earlier procedure differs. Now, apart from warrant procedure before the magistrate on police report and otherwise then on police report, there is also summons triable cases by the magistrate. Now, in a summons triable cases, there is just single procedure, there is no two procedures. So, whether the case has been instituted on police report or it has been instituted on a complaint, the first procedure is again getting to be sure that the copies have been served upon the accused, and then the examination of the accused under section 255 CRPC. Now, here what happens is the magistrate explains to the accused the substance of the accusation made against him. So the substance of the accusation is explained to the accused, and here the accused may again plead guilty, not plead guilty, or refuse to plead. And then after this is completed, what the magistrate must do is he will write an order explaining write an order with regards to the plea of the accused. And in that order, it must be clear, the substance of the accusation must be clearly written down. And then once that is done, the magistrate proceeds to hold trial of the case, and the trial, as mentioned earlier, is the same. First, the prosecution will be asked to enter into evidence, then the accused will be allowed to cross-examine, then re-examination if necessary, then again the accused will be directed to enter into his defense, then again bring his evidence, and then if it is found that the accused is guilty, he will be convicted, and if he is found to be innocent, he will be acquitted. Now, in all cases, whether in summons trial before a magistrate and in warrant trial before magistrate, in either of the cases, what is important is in every case where the magistrate proceeds to convict the accused, two sections come into play. One is section 325 CRPC and 360 CRPC. 235 CRPC and 360 CRPC. Now, what does this mean? Now, this basically means that if a magistrate holds trial, now the CRPC provides the magistrate with jurisdiction and power only to impose a certain amount of sentence. Like, for example, a magistrate of the first class can impose a sentence of around 3 years. Then a magistrate of the first class in the cadre of the civil judge senior division, or CJMs or ACJMs as we call them, may impose sentences to 7 years. The fine amount is also limited. So now when there is an offense which is tried by the magistrate, and the magistrate finds that the offense is such that he may need to impose a sentence which is beyond its power. That means he wants to impose a sentence of, say, around 10 years. But the magistrate is not able to impose that sentence because that is not within his jurisdiction. So what does he do? Then in such circumstances, the magistrate will send the matter to the court who can impose such sentence, and then request that the court look into the evidence and impose the sentence which is found fit. Now, another section which is important is 360 of the CRPC. Now, this 360 of the CRPC is basically putting in the principle of the welfaristic society that we have, and in the principle that we will not punish the criminal but the crime. So in these cases, considering the mitigating circumstances, considering the facts and circumstances, the nature of the offense, the magistrate may proceed not to convict the accused. So what does he do then? Then he may either proceed to release the accused either on probation of good conduct or after admonition. Now, this 360 CRPC has become almost redundant after the promulgation of the Probation of Offenders Act. In the Probation of Offenders Act, under Section 3 and Section 4, what is found is the similar provisions as found in Section 360 is there, where again you may release the accused on admonition, again depending upon the circumstances and the background of the accused, the nature of the offense committed, or on probation of good conduct. In this probation of good conduct, it may either be under supervision of the probationary officers who are appointed under the Probation of Offenders Act, or it may just be probation of good conduct generally. Now, what is important in the Probation of Offenders Act is that any accused who is released under the Probation of Offenders Act will not suffer the same implications or liabilities as he would suffer if he has been convicted under the criminal law. Now, despite the fact that it has the similar ramifications as that of an acquittal, the magistrate may, or any court who is making use of the provisions of the Probation of Offenders Act, may direct the accused, although released on probation, to pay fine. And this payment of fine, again, will not accrue any liability of conviction upon the accused. So this is basically the two provisions where magistrate wishes to convict but does not convict, and where he wishes to convict but cannot impose the sentence. Now, this covers the trial before a magistrate. Now, another important is trial before a sessions court. Now, when does a trial before a sessions court begin? We've already discussed that the CRPC categorizes some offences into summons triable, warrant triable, sessions triable, all these kind of things. So wherever the CRPC states that an offence is triable by the sessions court, then the sessions court will have jurisdiction to try the said offence. Okay. Now, when does the trial before a sessions court begin? It begins with the commitment of the case by the magistrate having jurisdiction to take cognizance before the court of trial. Now, once the accused is produced before the court of trial, the first matter of business is to again examine the documents and all that. Now, in a sessions court, the prosecution is always led by a public prosecutor. And the trial begins by the public prosecutor presenting his case before the court, and in short, he will give you a statement with regards to how he intends to prove the case, what evidences he will bring before the court, and what are the witnesses he will be examining before the court. Now, once this is done, the sessions court then again frames charge, considers the charge against the accused. Now, if the sessions court finds that there are sufficient grounds to proceed against the accused from the materials on record, from the CD, from the charge sheet, from all the documents that have been placed before it by the prosecution, and in certain cases also by the accused, the court may proceed to frame charge against the accused. Now, how do they frame charge? Again, in the similar manner as in the magistrate case, the contents of the charge will be read over, the offences will be explained, and the charges will be noted. Now, here again the accused has the liberty to either plead guilty, not plead guilty, or refuse to plead. So again, similarly. Now, here there is an important procedure is when the court finds, after hearing both the accused and the prosecution and considering all the documents, if the court finds that there is no ground or the grounds in the record are not sufficient to proceed against the accused, then the Court of Sessions may forthwith discharge the accused. So here there is possibility of discharge at the time of consideration of charge. Now, if the accused is discharged, the court will order the discharge and give reasons for discharging the accused. And here the case ends for the accused. Now, supposing charge is framed against the accused, then again the charge must be written in the pro forma, the contents must be read out and explained, his pleadings must be recorded, and the prosecution again, after this is completed, proceeds to give evidence. After his evidence is completed, the prosecution will give. After his evidence is completed, the prosecution will, the accused will be asked to enter into his defense, and the accused will again, if necessary, give evidence, and if no evidence is given, then on the basis of the evidence, we again proceed with either convicting the accused or acquitting the accused. Now, What is very important with regards to all these is there is a special section which is section 313 CRPC. Now this is examination of the accused under section 313 CRPC. Now all the courts, whether trying summons cases, warrants cases, or the sessions court, what it does is before the accused is directed to enter into its defense and produce his evidence, will examine the accused. Now, this examination is done. It can be done at any time by the court if it thinks fit, and the court, it may be specific examination or it may be general examination. Now, if the court finds that there is sufficient materials in the evidence, examination under section 313 is when the court finds that there is grounds incriminating evidence against the accused, then the accused will be confronted with such evidence, and then he will be asked to give explanation as to what he has to say regarding his defense about these evidence. Now again here, when an accused is examined under section 313 CRPC, the accused is not compelled to answer. He may answer, he may not answer, or he may give a general answer. Now, although he may not be compelled to answer, what is important is if the accused answers, then his answers may be considered at the time of judgment either to convict him or to acquit him. So this is generally an examination under section 313 CRPC, which is compulsory with regards to the trial of criminal cases. Now, another important aspect with regards to trial of criminal cases in a sessions court is when all the evidence of the prosecution is completed, and on the basis of the evidence recorded, the court finds that there are no grounds to convict the accused or to sentence the accused, then the court may order the acquittal of the accused under section 232 CRPC. Now this is a special ground, this is a special procedure in the cases tried by the sessions court. Now, apart from a summons tribal case and a warrant tribal case, there is something called the summary trial, which is provided in the CRPC. Now, this summary trial is with regards to petty offences only. Now, I have given details with regards to the procedure of summary trial in the study material that is provided to you, but what you must understand is a summary trial does not actually have the whole procedure with regards to recording of plea and evidence and all that. In a summary trial, the accused is explained what is the offense, and then the evidence in itself, the whole entire evidence is not taken, just the substance of the evidence is taken, and on the basis of the substance of the evidence, the court proceeds to either acquit or convict the accused. So this basically in gist is the procedure with regards to trial in a criminal cases. Okay, thank you.